Hello, this is Sudhir Kumar Dwivedi, Assistant Professor, Gemtech School of Law, Greater Noida. The topic which I am going to discuss is definition which has been provided in Indian Evidence Act. And as we know that the definition clause, that is section 3, contains definition of various provision. We will discuss one by one all the definitions. What is the essence, what is the meaning of those definitions? The first definition we will discuss is the definition of fact. If we see the section 3 of the Indian Evidence Act, it provides that anything, state of thing or relation of things capable of being perceived by the senses is the fact. And second point is that any mental condition of which any person is conscious is also a fact. So if we analyze the definition given in the Indian Evidence Act, we find that the Indian Evidence Act talks about the two types of the fact. First, which may be perceived by the senses, and we know there are 5 senses of which something can be perceived. Like we have 5 senses: first, eye, ear, nose, skin. So if anything can be perceived by the senses, that is a fact under the Indian Evidence Act. For example, which the illustration which has been given in the Bare Act itself is that there are certain objects arranged in certain order in certain place is a fact. Why it is a fact? Because it can be perceived by the one sense, that is by eye, that something is arranged in certain order in certain place. So this is a fact. And the second one is that a man heard or saw something is a fact. I said there are 5 senses, and if any sense is perceiving something, then it is a fact. For example, if I saw something, it is a fact. If I heard something, it is a fact. So if anything can be perceived by the 5 senses, it falls in the definition of the fact under the Indian Evidence Act. And the second one is that is the mental condition of any person. A mental consciousness is also considered as a fact in Indian Evidence Act. For example, suppose someone has formed some opinion regarding anything. For example, you can say that opinion of an expert, that for example, you can discuss that if someone has been given the poison, then the opinion of the expert that such particular type of the poison may have been given to the victim is a fact. The opinion which will be revealed by the expert is something psychological fact, which is his mental condition, that is also considered as a fact. We can say the fact which only exists in the mind of individual, for example, sensation or recollection of which man is conscious, his desire, his intention is doing in particular acts, all is a fact which fall in the second category, that is the mental condition of any person is also considered as a fact. Mental consciousness is also considered as a fact in Indian Evidence Act. In nutshell, it can be said that the Indian Evidence Act talks about the two types of the fact: physical fact and psychological fact. The next definition is what is relevant. As per section 3 of the Indian Evidence Act, one fact is said to be relevant to another when the one is connected with the other in any of the ways referred to in the provisions of this act relating to the relevancy of the fact. So if we analyze the definition, we find that the act doesn't give any definition of the word relevant. It only lays down that a fact becomes relevant only when it is connected with the other facts in any of the ways referred to in this act relating to the relevancy of facts. As we know that under chapter 2 section 5 to 55, deal with the relevancy of fact. A fact, in order to be a relevant fact, must be connected with the facts in issue or with any other relevant fact in any of the ways referred to section 5 to 55. A fact not so connected is not a relevant fact. The scheme of the act seems to be to make all relevant facts admissible. If we analyze, we can say if any fact which is going to solve the fact in issue or which is connected with the fact in issue and it is falling in the category of from section 5 to 55, then only it is relevant. There may be certain fact which may be helpful to decide the case, but that fact is not relevant if they are not falling within the category of section 5 to 55. Suppose a murder has taken place in an area and a person has seen the whole event, but he didn't appear before the court. But whatever he has seen during the incident, he speak all the things to a third person, and that third person is appearing before the court as speaking about the incidents. This fact is not admissible in Indian Evidence Act. Reason being, it is falling in the category of hearsay evidence. As we said already discussed, that the fact may be relevant to decide the case, but since it is not falling within the category of from section 5 to 5 or 55 of the Indian Evidence Act, that's why though it may be relevant to decide the case, but since it is not falling within the category of section 5 to 55, it will not be admissible. So for the purpose of this Indian Evidence Act, fact must be a fact which is related with the fact in issue and is falling in the category of relevancy of facts which is given from section 5 to 55 of the Indian Evidence Act. The next definition which is given in the act is the fact in issue, which is very important. And to understand the Indian Evidence Act, if one student is not able to understand what is the fact in issue, the whole Evidence Act will not be understandable by the student, because it is the basic, or you can say the root of every clause. Student must have to understand what is the issue, then only they can understand what is the use of the evidence, how it is to be utilized. The definition which has been given in Indian Evidence Act, it said that the expression fact in issue means and includes any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceeding necessary follow. So if we see the definition which has been given in the act, is given in some technical language, but it is very easy to understand if we keep in mind certain things, that the fact, if the fact in issue will be decided, then it will create either right or liability. We have already discussed in our first lecture that ultimately the aim, the thing is that if something is proved, it will create either right or it will create either liability. So something, what is the disputed point between the two parties, is generally considered as a fact in issue. It can be understand like this, that the fact in issue may be themselves or in connection with other facts constitute such state of thing that the existence of the disputed right or liability would be legal inference from them. The expression means the matter which are in dispute or which form the subject matter of the investigation. In nutshell, student can keep in mind that what is the matter of dispute, or what is the subject matter of the investigation is generally fact issue, and if that point is decided, then it will either create the right or it will create either the liability. It can be said that fact in issue are those facts which are alleged by one party and denied by the other. In the pleading in civil case, are alleged by the prosecution and denied by the accused in the criminal case. So I already discussed in the very first lecture that what is the disputed point between the two parties is generally considered as a fact in issue. It can be understood by way of an example. Suppose A is a cashier in a factory. It is his duty to bring money from bank and distribute the money to the laborers. A case under section 409 of the IPC, that is the criminal breach of trust, is started against him. The case against him is that he brought 25,000 from the bank and misappropriated around 13,000 out of it. It says in his defense that he brought the cash from the bank and he was to go on leave that day. He, according to the direction of the manager of the company, handed over the 25,000 to Mr. B, the assistant cashier. Now the question is whether A is liable for the criminal breach of trust. Now B should know what is the criminal breach of trust. Whoever being in any manner entrusted with the property dishonestly misappropriates or converts to his own use that property is guilty of criminal breach of trust. So, according to this definition, before a person is held guilty of criminal breach of trust, it is to be found that he has been entrusted with some property, that he has dishonestly misappropriated that property. Now, if we refer the aforesaid illustration, the question is whether A is liable for the criminal breach of trust or not. Before the court holds A liable for the criminal breach of trust, it has to decide whether A handed over money to B, whether A worked that day in office, whether B worked that day and distributed the money. The fact that A handed over the money to B, the fact that A did not work in the office that day, the fact that B worked and distributed the money to the laborers that day, the guilt or innocence of A follows, and so these are fact in issue in trial of A for the criminal breach of trust. So if the fact that A did not work in the office that day, if it is proved, then and that the fact that B worked and that day and distributed the money to the laborers, if it is proved, then the liability of the B is proved, and the charges which has been made against the A will not be proved, because it will prove the fact that he has handed over the money to his assistant cashier to the B. So the liability which has been created against him is not proved, because the ingredients of the section of 409 is not proved. So there is no criminal breach of trust has been committed by the A. Let us take another example which is given in your Bail Act as well, that A is accused of the murder of B. At his trial, the following facts may be in issue: that A caused B's death, that A intended to cause B's death, that A had received grave and sudden provocation from B, that at the time of doing the act which caused B's death was, by reason of unsoundness of mind, incapable of knowing the nature. If you see the various fact here, you can see that here should be one fact in issue generally for the student, that whether A caused the B's death or not. Why the other two fact has been in issue? The reason being, suppose if it has been proved that there was grave sudden provocation, then it will not fall in the category of death. And if it has been proved if the contention has been taken by the A that grave and sudden provocation has been caused by the B, and the party is able to prove that thing, in that case the murder will not prove. So this is also fact in issue. And the other point that is why the other third point is an issue. The reason being, suppose if the part A is able to prove his unsoundness of mind or incapable of knowing the nature of things, then his act will fall in the category of the general exception, and he will not be liable for the act even he has committed the homicide, though still he will not be liable. That's why these facts also are an issue. The general fact is that the murder has been committed, and the question is whether A has committed the murder or B is the fact in issue in general nature. But if there are some associated facts which may be useful to decide the ultimate liability of the person or the accused, will also be a fact in issue. The next point or the next definition is the definition of the evidence, which is very important. What is the evidence as per the Indian Evidence Act? If we see the definition which has been given in the act, it is that all statement which the court permits or requires to be made before it by witnesses in relation to matter of fact under inquiry, such statement are called oral evidence, and all documents including the electronic record produced for the inspection of the court, such documents are called documentary evidence. The word electronic record has been inserted by the IT Amendment Act 2000 in the Indian Evidence Act, that is Information Technology Act. Now if we analyze the definition of the word evidence under the Indian Evidence Act, we find that Act includes only the statement of witnesses and document produced. This definition is not complete. The reason being, there are so many things which are as good evidence as statements and documents, but they are excluded from the definition of the evidence. Suppose, for example, a magistrate or a session judge may question the accused, and the answer must be used against him. Every day at a trial, questions are put to the accused as to whether they committed the crime with which they have been charged, and very often the accused answers in affirmative. He admits his guilt and his statement is considered by the court. But according to the definition in the Evidence Act, this statement of accused is not an evidence, but in real scenario it is considered as evidence. The demeanor, that is section 280 CRPC of a witnesses, demeanor means how of the witnesses, are also taken into consideration by the court, but this is also not evidence according to the act. The courts, criminal or civil, make local inspection and do the memorandum prepared by them forms part of the record and also utilized by the court in weighing the evidence. But when tested the definition of the act, it is not falling in the category of the evidence, but in real sense, but in practical sense, all is considered as the evidence because that are taken into consideration by the court. So it can be said that the definition of evidence given in Indian Evidence Act is incomplete and defective. It excludes the statement and admission of parties, their conduct and demeanor before the court, circumstances coming under the direct cognizance of the court, facts of which the court can take judicial notice of, and the fact which the court must or may presume. All has been excluded, but generally they are considered as evidence. As we have already discussed, there are certain things like affidavit, as we discussed in the previous lecture, that the act doesn't apply on the affidavit, but affidavit is also considered sometimes as a mode of proof. In nutshell, it can be said that the Indian Evidence Act provides two types of the evidence, talks about the two types of the evidence. One is the oral statement by the witnesses, and the second is the document. And on this basis, can be said there are two types of the evidence: oral evidence and documentary evidence. So it can be said that evidence is a body of facts and information indicating or adjudicating the value of any fact or evidence. That's all about the definition clause of the Indian Evidence Act. Thank you.